welcome to Mourant's Vlog Series looking at points in practice. Today I'll be looking at a few practical takeaway points from case law as well as upcoming changes in the law which might affect you and your clients. When a client comes to you to establish a trust, they often want to know how much control and influence they can retain without it causing an issue for them. As you may know, Section 15 of our Guernsey Trust Law allows for a wide range of reserved powers by the trustee, which, if reserved to the settler or a third party, would not result in the trust being invalid. These include the power to vary the trust, pay out money, give investment directions, change the trustee, investment manager or proper law of the trust, or to change who is included in its class of beneficiaries. These powers can be fiduciary or non-fiduciary, provided that the wording used is direct and express in its meaning. As we've seen in the recent cases of Pugachev and Webb, settlers who do not clearly give up their assets so as to create immediate rights in another person, and who reserve several powers to themselves so that ultimately they can recall those assets to their estates fairly easily, will put their planning at risk from creditors or matrimonial claims. It is advisable to carefully consider the facts surrounding your clients and to advise them to limit their influence over the trust so that their planning is more robust. There are several ways this can be done for the client to assist them with any concerns they might have in handing over the assets while retaining a measure of control which is not sufficient enough to bring a claim of an illusory or sham trust arrangement. Where you have a new settlement being discussed or you are reviewing your trusts, the level of direct or indirect influence held and by whom is something to always consider, so as to understand the risks that the trust might be exposed to. The case of Rosnano is important because it examines when a beneficiary can request that all of the trust assets be distributed to them, which would result in the trust terminating. It's also an area of law where Guernsey and the UK diverge in approach. Under Section 53(3) of the Guernsey Trust Law, beneficiaries are able to require a trustee to terminate a trust and distribute trust property to beneficiaries where all of them are in existence and can be ascertained. This is generally seen as the codification of the principle set out in the English case of Saunders and Vautier. In the case of Rosnano, the sole beneficiary brought an application to terminate the trust and receive all of the trust assets. However, the trustees contested this claim on the basis that they had a power to add to the beneficial class and therefore the class was not closed and the trust could not be terminated. The court drew a distinction between the sole beneficiary and the power to add beneficiaries, and it held that at the relevant time, the sole beneficiary was the only beneficiary and therefore they could rely on Section 53(3) of the Guernsey Trust Law to terminate the trust. This decision was appealed and upheld at the Court of Appeal. The court noted that it had an overriding discretion not to agree to the termination where it thought fit. This right is set out in Section 53(4) of the Guernsey Trust Law, and this is where Guernsey law and the UK law diverge. So how can trustees ensure that they are always considering the settler's long-term intentions? Well, trustees can periodically review the letters of wishes they have on file and consider, in light of reporting of course, whether or not they should be adding anyone to the beneficial class, so as to properly reflect the settler's intentions and wishes. If there's a principal family and an ultimate charity nominated, what would happen if the principal family of beneficiaries were all in a common accident? Would it reflect the settler's wishes if the money all went to that charity? If that's the case, then great, but if not, you need to start having further conversations with your settlers and beneficiaries about who should benefit in those circumstances and when they should be added to the beneficial class. The new law has now been registered before the Royal Court, which is the final step in it becoming a law in Guernsey, and we expect it to come into effect by the end of 2021. Currently, a person can put in place powers of attorney that last up until the point when a person loses capacity, and then a guardianship order is required. The new law, which would be similar to the UK position, would allow for LPAs to endure beyond the loss of capacity. This is helpful as when someone is losing capacity, their ability to make decisions can vary depending on their health and their time of day. In addition, the bar set for any particular decision can vary greatly depending on its importance. LPAs are something that you should start to discuss with your clients, particularly where there are discretionary funds under management with you. In the UK, particular wording is required to enable the attorney to step into the shoes of the donor where there are funds under discretionary management, and investment institutions will not accept instructions from attorneys without it. It is also possible to put in place advanced care plans, which can help trustees with budgeting for the future needs of the beneficiaries. Where no procedural step is taken in relation to an action within a year and a day, then it is regarded under customary law as per me. It is not automatic, but the defendant can now apply for the cause to be struck out, and if they succeed, the plaintiff's cause would be extinguished. The plaintiff may apply to the court for an order that the action be restored, and it would be for the court to determine whether that restoration would be fair in all the circumstances. In case you missed Alexander's pension update last week, I just wanted to also mention that the secondary pensions legislation is expected to be introduced from 1 January 2023. This will be an auto-enrolment pension with some limitations in place, for example for students and seasonal workers. This has been on the table for some time in Guernsey, and it is well worth looking ahead and reviewing your pension trusts, as there may be changes such as a widening of your eligibility rules that need to be considered. Thank you.